All right. Hello, everybody. So we've got all of you here in person. We have several people who are joining us on Zoom as well. So just to give you a heads up, if you have questions, you can feel free to raise your hand and stop me, but I'll also give everybody an opportunity to raise their questions at the end of the presentation as well. My name is Heather Cwiklinski. I'm the supervisor of the Trust Administration and Probate Department here. And I'm going to talk a lot about what we do within our department. And also today here we have Terri Macklin and Caleb Gonzalez. They are the two supervising attorneys within the department. And over here we have Donna Wolf, and she is one of the paralegals in the department. And the way that we do things in our department specifically is each of the attorneys supervises the cases. They have about a 50-50 split on a caseload. Myself and Donna do the majority of the workload for each file, but everything is reviewed and supervised by the attorney. We run all of our questions by them. They oversee all of the work, make sure everything's up to par throughout the process. So most of what we're going to talk about today is just what to expect from the process after a loved one has passed away. So the things that we deal with primarily in our department are the administration of a trust in the event that somebody passed away with assets held in their trust, or the probate process, which is what we have to go through when assets were not funded into a trust and did not name a direct beneficiary, in which case that needs to go through the probate court. So the first step after a loved one has passed away is just to notify family members, get everybody on the same page, let them know what's happened, secure their property. So this refers specifically to real estate in particular, get a hold of keys, get the property locked down, vehicles, that sort of thing. You can sort of start collecting information on other types of assets as you're able. Those are things that we like to see when you do eventually come to us, but they're not needed right away. Look for legal documents. So if this is a client of ours, most of our clients will have a big binder that says the law offices of David Carrier right on it. That's going to contain trust documents, will, power of attorney, all of those types of documents. If they did not work with us, they will likely still have some sort of folder or a binder that contains documents like that. Make funeral arrangements. A death certificate will be issued through the funeral home, and that's one of the important pieces of documentation that you'll need in order to move forward with either the trust administration process or with probate, depending on what's needed. After all of that has been done and you have a death certificate in hand, at that time, it's a good idea to contact us to make an appointment. That initial appointment would be with Terri or with Caleb, and they'll be able to take a look at the estate planning documents that are in place, if there are any, a look at the assets, and make a recommendation as to a plan, whether or not we're doing trust administration, probate of the estate, or a combination of the two. All right, so question, are you a beneficiary? A beneficiary is a person or entity entitled to receive money or some other benefits upon the death of a benefactor. So you could be a beneficiary of a specific bequest. That might look like a certain amount of cash allotted for you to receive. You might be a beneficiary of a piece of real property. Let's say a loved one leaves a house to you or a vehicle. You could be a residuary beneficiary. What that means is you're entitled to receive a portion of the entirety of an estate or what's funded into a trust. Or a contingent beneficiary. So that would mean that your status as a beneficiary would only come into play if somebody else is not able to receive their portion. All right, so the first thing we're going to talk about is what happens if somebody passes away and their assets are all held in a trust. So a trust is an agreement in which one person holds and manages property for the benefit of another in order to avoid probate and protect assets for the future. A trustee is the person who is responsible for handling the assets held by the trust and following the terms of the trust. So for most people, If you have a trust while you are alive, you are more than likely the trustee of your own trust. Over time, some people choose to appoint a co-trustee to serve alongside them. You see this often with parents and children. You might appoint a child as a co-trustee with you just to make things easier down the road. Or you might be named as a successor trustee in somebody's trust, in which you would only become the trustee upon their passing. So the timeline for trust administration looks like this. We start by notifying beneficiaries. We publish a notice to creditors. We prepare an inventory. We liquidate all of the assets, prepare an accounting of the trust, make distributions. So beneficiaries have certain rights according to Michigan law. Michigan law mandates that all beneficiaries must be kept reasonably informed throughout the process. As a beneficiary, you are entitled to the sections of the trust that specifically pertain to you. So if you are not the trustee, but you are a beneficiary of the trust, there's a chance you might only receive portions of the trust to review. And that's only because legally, you're not necessarily entitled to the entire trust. Some trustees will choose to share the entire trust, some don't, and that's up to them. A trustee has a duty to make every effort to locate all beneficiaries. When we have a trust, for the most part, we have contact information for beneficiaries before a grantor has even passed away. Sometimes we run into situations where, and particularly on the probate side of things, we don't necessarily have addresses for beneficiaries. So we work with our clients to try to track people down, do the best we can to locate them. And there are processes we can follow in the event that a beneficiary cannot be located. The next step is to publish a notice to creditors. So this is a notice that's published in a local newspaper. It notifies all creditors that they have a 4-month period within which to present any claims that they have against the estate. After that 4 months, all claims are forever barred. So if you don't publish the notice to creditors, you are open to, I believe, 4 years. Is it 4 years for creditors to come forward? 3 years for creditors to come forward. By making this publication, it reduces it to that 4 months. Creditors who make claims are not necessarily guaranteed payment. So when it comes to the administration of a trust, all of the assets that are funded into a trust are likely off the table for creditors. So if you're working with us and we're assisting you with this process, we will respond to those creditors on your behalf, notify them that there are no assets in the estate, and that we cannot satisfy their claim. The next step is to prepare an inventory. So the inventory is a list of all of the assets that were in the trust at the time of the decedent's passing and an estimated value of each of those assets. Examples of assets could be a house or other real property, investment accounts, bank accounts, life insurance policies, IRAs, anything that can be titled in the name of a trust or name a trust as a beneficiary. The next step in the process is to liquidate all of the assets that are held in trust. Again, that's something that our team would be assisting with. We help with calling all of the companies, collecting claim forms, speaking with representatives from the companies, filling out claim forms. Often this will look like cashing out accounts. All of those funds are payable to the trust. So the idea is as all of the assets are liquidated, you're consolidating the liquid cash into an account in the name of the trust. That account runs under a separate tax ID number that is assigned to the trust. And that's also something that we would assist with. Once all of the assets held in a trust have been liquidated, we prepare what's called an accounting of the trust. This is another legal requirement. So we need to be able to show everything that was in the trust at the time that the decedent passed away. So that would be your inventory list. Everything that came out of the trust. So that's any sort of expenses that needed to be paid. Funeral expenses are considered an expense of the trust. Anything that needs to be paid to maintain a real property that's held in the trust can all be paid out of those funds. And any income that the trust generates shows on the accounting. Each beneficiary is entitled to receive a full copy of that accounting. So that way they know exactly what happened during the administration of the trust, and it's completely transparent. Again, that accounting begins with the inventory value and includes all of the income and expenses leading up to the final distributions that are made to each beneficiary. Some examples of income are interest, refund checks, life insurance payouts, and again, expenses could be in the form of utilities, funeral expenses, or insurance. All right, so there are some different distribution options that are built into our trusts in particular. One of those options is to receive your inheritance in what's called a separate share trust. So that is, you could also think of it as an inheritance trust. It's a trust for only what you're inheriting from the grantor's trust. It runs under a separate tax ID number, and it is only for inherited assets. It's controlled by the beneficiary and a co-trustee of their choosing. And the benefits are that it adds protection. All of the assets that are in your separate share trust are automatically off the table for creditors. And they also do not count against you if you need to be approved for Medicaid or any other income-based government benefits. So it's a good option in particular for a beneficiary who maybe is already receiving government benefits that could potentially be impacted by receiving an inheritance, or a beneficiary who has any creditor issues or anything like that. The funds are not counted against you as an individual. So part of that is because it is running under a separate tax ID number rather than your own social security number. Those assets never touch your name or your social security number. Another option is a supplemental needs trust. This is very similar to the separate share trust. The main difference is that it is not controlled by the beneficiary. So usually when we use a supplemental needs trust, it's a choice that the trustee has made or that the grantor made before they passed away for a particular beneficiary. And we often see this in the event that a beneficiary maybe does not have good management of their money, or if they have any sort of creditor issues, used frequently for disabled beneficiaries, anybody who could benefit having their funds protected. And lastly, in trust administration, we come to final distributions. So a final distribution cannot be made until the notice to creditors expires. So already you're looking at least a 4-month wait after somebody's passed away. And once that notice has been published, before distributions are made to beneficiaries. Because of that, administering a trust typically takes on average 6 to 9 months. This completely depends on what types of assets we're looking at, what family dynamics are. Oftentimes, things like real estate can slow things down a little bit. If you need to get a house ready to sell and on the market, that can potentially take up a little bit of time, especially if you're waiting for peak time to put it on the market. But if we're looking at just standard accounts, it can be as quick as that 4 to 5 months it takes for the notice to creditors to run. At the end of trust administration, our office sends each beneficiary an agreement and release document, as well as a copy of the trust accounting so that they can take a look at all of the money that came into and out of the trust. They can see how much they're inheriting, and they sign off on that amount, agreeing to that and releasing the trustee from any liability. And that's a document that we have signed in front of a notary. And once the trustee has received the agreement and release document back from all beneficiaries, at that time, the trustee will make final distributions out of the trust. Any questions about trust administration in particular? Yes. Yep, so if one of the beneficiaries is receiving a piece of real property as part of their distribution, obviously we're not going to worry about selling it or liquidating it per se, but we would handle the transfer of the property during that step. So we would prepare a deed and all of the related assessor's documents to get the house transferred to the beneficiary that's receiving it. Yeah, yep. Yes,
Said the beneficiaries get a full accounting.
correct.
What's the definition of a beneficiary? As in, if I make a special allocation to somebody for $5,000,
Mm-hmm.
are they going to get a full accounting of the whole thing?
That's a great question. So for those on Zoom, the question was, are all beneficiaries entitled to a full accounting, even those who are only receiving a specific bequest? The answer is no. Those beneficiaries are not necessarily entitled to a full accounting. If all they get is a flat dollar amount, then that's all they need to receive. They don't need to receive an accounting. Now, if we're looking at a situation where the specific bequest has language, in our trusts, some of the specific bequests will say like $5,000 or 1% of the trust property. If it has language like that, then we do provide a trust accounting so that they can see whether or not they were entitled to that 1% or the 5,000, if that makes sense.
How about if an asset is given to a particular beneficiary for their life, and upon their death, it goes to someone else?
Can you give an example of what something like that might be? Like a piece of property or?
One child that when they die, it goes to a different grandchild.
Okay, so in our trusts, we include a section for each beneficiary that goes over what should happen in the event of their death. So that applies if the beneficiary happened to pass away before the grantor, then we have a plan in place for what should happen to their share. But that also comes into play if the beneficiary received an inheritance and didn't exercise their own power of appointment over that inheritance. So what that means is, if a beneficiary, for instance, receives a house, and if it's transferred into their name, then from there, it's up to them what they do with it. If it's, so say you receive a piece of property out of a trust, it would be transferred out of the trust and into your name as an individual.
Property to someone with a life interest to the death.
A life estate, yes, you could. So I guess technically a trust could outline a distribution, but include a life estate. It would just have to say it in the specific bequest. So you would just include that in the deed that was prepared.
What I'm specifically thinking of is someone might give a farm and the house goes to one person only for their life. Upon their death, it goes to someone else. Maybe I should come up.
Yeah, sure. We have Terri Macklin coming up front and we have one microphone, so.
I don't fall down.
There you go.
What you're kind of referring to is what we often call it commonly a ladybird deed, where it says from me to myself or to somebody for their life, and if they can do anything what they want with it, and then to another person. There are some problems with those because sometimes the remainder person that you're naming on there at the time the person with the life estate dies, that person's not living anymore. It could go to a trust. What we would probably recommend with a farm, though, is a separate trust for it. We sometimes do cottage trust within the main trust for estate planning purposes. And that's what we would recommend for a farm would be the best way is to set it up in some sort of a trust within that trust. So the farm is there in that sub-trust, so to speak. It would say so-and-so has a life estate, as long as they maintain it, they can live there, blah, blah, blah. Upon their death, then this is what happens to it. But if we don't have that language, we sometimes are restricted. But usually, if you've done a trust through our office, our attorneys that do the estate planning are looking at all those things. So you got a cottage, you got a farm that maybe it's going to be continued being farmed or not, or maybe it's a centennial farm. But usually we include all of that in their estate planning. So, okay.
A home has a lady pass through with a TR-29 from the Secretary of State. My personal belongings are worth less than $5,000. Do I need a trust?
We usually recommend if you have real estate and any bank accounts that you probably do need a trust. What the person just asked about having everything with a beneficiary on it, that works if that person's alive at the time of your death. But what if they aren't? What if something happens to that person? What if they're in a nursing home? What if they get hurt and they can't manage the money? And so we would recommend a trust anytime you got a piece of real estate and you got some other money. It's usually a good idea. We want to make sure that those beneficiaries don't pass away, because one of the things that is out there, and I've seen it happen, is if you are on Medicaid in a nursing home for long-term care, and most people can't afford nursing homes, they're very expensive. So they do get on Medicaid. And what happens is when that person dies, if they have any assets that are going to go through probate court because they don't have a trust, the state of Michigan has a law called a state recovery, and the state of Michigan can file a claim in that probate estate and get reimbursed. So that's the real risk. You know, if you've got beneficiaries on and they die before the first person, and you don't update that because maybe you can't, you might not be competent at the time your beneficiaries pass away. The trust we provide for all the contingencies, and we keep those assets out of probate, so then the state can't come in and recover them.
Right. Do we have any other questions before we move on to probate? Yes.
About separate trusts, supplemental trusts, if you have, let's say, relatively few beneficiaries, there's no business involved and things like that. Do you need to go through that process to have a trust within a trust? Or can you just have the trustee distribute the proceeds of whatever is in the trust, the assets that are in the trust at that time?
Absolutely. So the question was if whether or not the beneficiary needs to utilize the separate share trust or a supplemental needs trust for their inheritance, or can they just receive it outright? They can absolutely receive their inheritance outright. And when we're going through the trust administration process, one of the things that we do is we send a letter to all of the beneficiaries. One reason for that is to just notify them of the process. By law, they're entitled to be kept reasonably informed. So that's one of the reasons that we send the letter, give them an idea of what to expect. And then we also outline all of the distribution options that they have. Number one being, I just want my share outright and free from a trust. What that would look like is when you get to the very end and final distributions are being made, the trustee just writes a check out of the trust account to that individual in their own name, and then they can take it and do what they want with it. It depends. So if the beneficiary is entitled to receive their share in a separate share trust, they can decide. The only time a beneficiary might not be making that decision is if the trust states that they should be receiving their share in a supplemental needs trust. And the only reason a trust would typically include that is if that person is disabled when the trust is established, has mental health issues, has major money issues, in which case the trust would already state that that beneficiary would receive it in that way. At the end of the day, though, it's up to the trustee's discretion. So if the trustee looks at that, right. So if the trustee looks at that and says, I don't really think they need the supplemental needs trust, they could decide to bypass that. Most of the trusts have some language that allow the trustee to make that decision.
Trustee
Mm-hmm.
can say, okay, make an accounting, do inventory, here's what we got in the trust. Trust says this beneficiary gets this percentage. Then it's just a matter of basically writing the check.
Right. Yep.
Beneficiary gets his money, but doesn't dictate the way in which that happens.
Right.
Okay.
Yeah.
Can you repeat that, Heather, so that people want to do that?
What he just said.
Yeah, so
What did it?
I know, I'm like, okay. So yes, it is up to the trustee's discretion as to how those distributions are made to the beneficiaries. If a trustee so chooses, they can follow the process, do an inventory and accounting, and at the end, just write checks directly to the beneficiaries.
That apply even, that's some language I brought for us.
Mhm.
If a beneficiary is over 40 years of age, does he have a right to? I don't know why he would, but I guess I'm looking, my concern is, I appointed trustee, and I appointed them for a reason, that I think they're going to manage whatever
Mhm.
in an appropriate fashion.
Mhm.
And I don't think that the beneficiary has a role in that. It should be, if it was, I would have maybe appointed the beneficiary a trustee. I don't know if that's a good idea.
Sure.
I-
So you're concerned that the beneficiary has the choice as to how to receive their inheritance?
Not to prevent them from getting it, but not to basically have any role in the administration of the trust.
Okay, so the beneficiaries, they don't have any role in the administration. The only rights that the beneficiaries really have are to be, exactly, but they do have a choice in most instances as to whether or not they receive that money outside of a trust or in something like a separate share trust. That is typically up to the beneficiary.
Why would a beneficiary get it inside a supplemental trust or a separate share trust?
So the separate share trust, the benefits for the beneficiary are all of their inheritances automatically off the table for creditors. So that would be beneficial for a beneficiary who has any creditor issues. And it also takes those funds off the table for any government, or sorry, any income-based government benefits. So if you have a beneficiary who's on, disability or receiving Medicaid, and this inheritance could potentially boot them off their benefits, it would be a good idea for them to have it protected. Yep, basically.
Ex-spouses.
Yes, in the event of divorce. Yes. So if none of those things apply and a beneficiary says, nope, I just want the cash, I've got a plan for it, I want to invest it, whatever.
They have a separate share trust
Hmm.
and it's transferred to them. At that point, don't they have control over that money?
Yes, it's been distributed to them. At that point, it's theirs.
In fact, they got money.
Correct.
It's just protected. now.
Exactly. That's right. Yep. Yes.
What if the trustee becomes?
Sure. So the question is, what if the trustee is not competent and is unable to fulfill their duties?
Between the time, the death and the time that it's
Sure.
time to distribute, what if they become capable?
Yep. So if a trustee becomes incapable of finishing out the process for whatever reason, trusts have a section regarding successor trustees that are built in. So it's going to kind of depend on the situation. So let's say the trustee passes away. At that point, though the rest of the people involved, the other interested parties, could take a look at the trust, see who the next in line trustee is, contact the law firm who's handling it, let them know the trustees passed away. The law firm can figure out who the next in line person is. Most trusts have several individuals listed who are to act in a specific order. And I know we in particular name a corporate trustee at the very end of that, just in case all of those individuals are unable to act. Another thing that could happen is, let's say the trustee didn't pass away, but maybe they're incompetent for other reasons, or they're just not doing their job. It depends on the trust. There's going to be different language for different documents, but there's usually some language in there that would allow beneficiaries, usually a majority of them, to appoint a new trustee if something like that were to happen.
So you include that in the trust?
At least our trusts, I know, have backup plans in place for if something like that were to happen.
Trusts also have a disability panel in them where, for the grantors as well as the trustees, it lists usually 3 or 4 people that can get together and vote that they're disabled. You can also have 2 doctors sign that they're not competent, but it's easier to use the disability, panel.
Mhm.
So there is a disability clause in there then. Yeah, that's.
In our documents, there is. I don't know other law firms, but ours, we have that in our.
Okay, so for those on Zoom, if you weren't able to hear, Terry was also pointing out that our trusts at Carrier Law in particular have a disability clause in them. So a majority of beneficiaries or those listed on a disability panel can all vote to deem a trustee disabled or incompetent so that a new trustee can be appointed. Okay. All right, we will circle back to questions once we get a chance to talk about the probate process. We'll see if anything else comes up. All right, so what if there is not a trust? A lot of times, if somebody has passed away without a trust, they might still have a will in place. A will is essentially an instruction manual to the court of what a person's wishes are after their passing. If somebody does not have a will, then the court itself has a predetermined list for how assets are to be distributed and for who handles the estate. A personal representative is the person who handles the administration process with the probate court. You've probably also heard of them referred to as executors. Means the same thing, but in Michigan, we call them a personal representative. So in a will, usually there is somebody identified as the personal representative, but until you've actually been appointed by the court, you are not acting as a personal representative. You're just considered to be a nominated personal representative. The probate timeline looks very, very similar to the trust administration timeline in terms of publishing that notice to creditors, preparing an inventory, liquidating assets, doing an accounting, and making distributions, but it's all handled through the courts. The most common form of probate is an informal probate process, in which we would prepare an application to open an informal probate case. We submit that to the court, and then we also send all of the beneficiaries or interested parties a copy of that application and the testimony to identify heirs to make them aware of the process. If you're a beneficiary in this case and you happen to receive these documents, there's nothing that you need to do. It's just to keep you aware. The next step in probate is once the estate has officially been opened, if you're a beneficiary, you'll receive a notice of appointment and you'll be notified of any attorney fees. Again, you don't need to take any action with that. You are just legally entitled to that information and to know that a personal representative has been appointed and that they're paying these attorney fees more than likely out of the estate. Next step, very similar to the administration of a trust, we are going to publish that notice to creditors so that the creditors only have that 4-month period within which to present their claims against the estate. We notify the friend of the court whenever anybody has passed away. The names of the beneficiaries are also provided to the friend of the court. And the reason for that is if a beneficiary owes any money, then their distribution could be garnished. Most frequently, we would see that in the event of child support that's been unpaid. For probate, we also prepare an inventory. This is a little bit different from trust administration, only because this actually gets filed with the court. So we need to provide a list of all of the assets that are subject to the estate. That's going to include any titled accounts, real estate, and tangible personal property, such as vehicles, boats, trailers. Anything of value needs to be included on that probate inventory, along with an approximate value. That is filed with the court, and the court will charge a fee based on the value of the inventory, and that needs to be paid by the personal representative out of the estate. An inventory only includes assets that were in the individual's name alone. So if there were any joint assets, any accounts that named another individual as a joint owner or real property that was owned by a married couple, for instance, that would not need to go through probate. It would become, the ownership would be that of the joint owner. Next step is to liquidate all of those assets. So once a personal representative has been appointed, the court will provide them with documents called letters of authority. And those will give that person the authority to conduct business on behalf of the estate. They can provide those letters to the financial institutions. They can provide those letters to a title company or a realtor in order to sell or transfer property. This will allow them to go through that liquidation process. All of the funds, as those assets are liquidated, are consolidated into an estate bank account. So very similar to what we do with a trust. With a trust, we have a trust bank account that gets its own tax ID number. In the probate process, we have an estate bank account that gets its own tax ID number. Yes.
As a representative. That's fine. At the same moment, that the action.
Once a representative has been appointed would be more accurate. Yes. Yeah, sorry. Next step in the process is accounting. We again need to provide a full accounting of the estate. We prepare an account of fiduciary form that outlines all of the expenses and the income subject to the estate. The personal representative signs off on that and it gets filed with the court. And it also gets sent out to all of the beneficiaries, the same as in the trust administration process. The accounting begins with the inventory value, includes all income and expenses up until final distributions are made. Again, this is very similar to with a trust. All of the income could be from interest, refund checks, life insurance payouts. Expenses are typically utilities, funeral expenses, or insurance. And final distributions, again, we don't make any final distributions until that notice to creditors has expired. Our office sends beneficiaries those same agreements and releases. They'll have a chance to review that accounting for the estate, take a look at what they're receiving and sign off either agreeing to that amount or not. Excuse me. And finally, after distributions have been made, probate needs to be closed. So we'll prepare a sworn statement to close. The personal representative signs off on that, stating that they've completed all the requirements. And again, that's going to be an inventory and accounting and final distributions from the estate. And we submit that to the court. As a beneficiary, you would receive a copy of that in the mail, just to give you a heads up that probate is being closed. And the court won't officially close the estate for another 28 days after they receive that document. Once they receive the sworn statement to close, it starts a 28-day clock within which they wait to see if any beneficiaries have any complaints or disagreements with the way that the estate's been handled. And probate must be open for a minimum of 6 months. So if for some reason the process doesn't take the full 6 months, distributions are made at that 4-month mark once the notice to creditors has expired, then we would just wait an additional 2 months before officially closing probate with the court. In the event that an estate is open for over a year, notice of continued administration is sent out to the court and to all of the beneficiaries. It will also list a reason for why the estate is still open. Most frequently, we see that when we're sitting on real estate, waiting for it to sell. And that is all I have for the probate side of things. Yes.
Subject to probate.
Yes.
Thinking about the fellow over there that talked about any joint accounts would
Go to the joint owner. Yep.
typically remaining spouse.
Yes.
And how about life insurance that has specific beneficiaries as opposed to being made out to a trust?
Yep.
That would be outside of probate?
Yep, as long as those beneficiaries are still living, that would also be outside of probate. So anything that, names a direct beneficiary or is titled in the name of a trust would avoid probate. There is also some exceptions if somebody had, I believe the threshold currently is about $28,000. If somebody passes away and had maybe just some random checking accounts with a sum of money, depending on who is trying to claim them, and it typically works best for children of a decedent, next of kin, to use this option, but we can use what's called an affidavit of decedent successor. It's also known as a small estate affidavit to claim some of those assets. So sometimes we're able to avoid probate that way as well. Correct. The total amount would have to be under that $28,000.
What happens with some people take one or two of their bank accounts as they get older and they put a child on,
Mm-hmm.
so they can write checks money.
Yep.
It's not the kid's money, it's the parents' money.
Mm-hmm.
But legally, if you join an account, that kid can write the check off. Is that count subject to probate? Are they saying, well, we have to know who put money in? How does that work?
So if the child is a joint owner, it avoids probate. Were you going to say something, Terry? Okay.
Don't recommend that. Let me come up, give my little spiel on that.
And I practiced law for many years. And I saw this happen one time with a father and son. The father's wife had passed and he said, oh, you know, a lot of times the surviving spouse dies not too long after they lose their spouse. So he wanted to make sure his son had access to his bank account to be able to pay his funeral. So, all right. So put son on the bank account with him as a joint owner. Lo and behold, the bank that he banked at, the son had also had a car loan with them, which they had repossessed the car and had a deficiency judgment they were trying to collect. And so they froze the dad's bank account. So dad's alive, son's on there. They ran a search, the bank did, and said, oh, he owes us money. So they froze the bank account. And the law is that, you know, it's basically like giving a gift to the son. And the law really was that the bank should have been able to get that other than Social Security, which, you know, that's a tracing thing. They can't take Social Security. But went to court anyway, and I wrote a nice little brief for the judge before I got in there and said, oh, it's for convenience only. It's just in case, you know, there's the, you know, he dies and all this. And the judge read it before we got into court, and it was here local in Kent County, and the attorney for the bank was from Detroit. And he's like, but Your Honor, he's like, I don't care. You mean to say that you're going to take all this elderly man's money? The son never put anything in, never took anything out of the bank account, and you're going to take all this older man's money? And the judge just says, no, not doing it. So long story short, even though there was law against it, but I wrote a brief, you know, kind of appealing to the judge's, you know, the heartstrings, so to speak. My coworker, and this was not at this firm, my coworker had the very same type of issue in Kentwood. I had Grand Rapids. And Kentwood, Judge Kelly at the time, and I like Judge Kelly, he's retired now, but he said, no, it's the banks. And she used my same brief, only, you know, tweaking it a little for the circumstances. So we don't recommend it because creditors can get to it. You know, you can argue it was for convenience only and that sort of thing, but we don't recommend that. If you want somebody that while they're living has access to that bank account, part of our estate planning packet, when you do your trust and will and everything here, are powers of attorney. And so there's one for healthcare and then there's one for financial. And so if somebody has a financial power of attorney, we usually make ours effective immediately when you sign it. And so you can access the bank account as well as they can. So they could write checks, that sort of thing. However, sometimes, and this often happens when someone dies, the bank will freeze that account. And the power of attorney is no longer good when you pass away. So some people do like to put on what they call a POD, pay on death beneficiary, on that bank account. So that way the child is not joint on it. They just would be entitled to it upon your death. Or if you have a trust, which we usually recommend, is put pay on death to the trust. And then your trustee would have access to it upon your death and be able to get that money to pay the funeral home. And the funeral homes usually want to be paid in 30 days. They do have payment programs or like credit card or like these care credit type things, where usually that gives you enough time to be able to access money if it is frozen. So does that answer your question? Yes, it would. Yep.
Here's my question. I'm aware of the problems with having them on when you're alive.
Right.
When you die, that's a joint account. I would imagine that's not going to be part of probate.
It would not if they're joint and if they're living. If they're not living and nobody's there and there's no pay on death, then that's going to go through probate. If you had a trust, you could do pay on death to the trust. And so then that avoids it, going through probate.
Dad has son on the bank account saying there's money left in here to pay my funeral. Dad
Yep.
years died, and the funeral home says, and he says, I don't have to pay that.
He doesn't. And whoever's on the life insurance does not have to use it for the funeral either. So
I'm told when someone dies, that the funeral home will ask somebody to sign.
if there's life insurance, when someone dies, the funeral home usually will say, will you assign that life insurance over to us? And so let's say the funeral's 10,000 and the life insurance is 15, then the funeral home will get it and then they'll cut the 5,000 back to the personal representative or the kids or the trustee, depending on the case.
Funeral. The details,
Mhm.
taken care of by your one kid that doesn't have a lick sense financially.
Mhm.
But you've got somebody else for the executive.
Okay.
You can have the kid with no common sense take care of the funeral, but they're not liable for penalties.
Correct. We have a document called a Thank you. A funeral representative designation. It's an additional document when you do your estate planning with us. It's in the packet and you get to choose a first choice and then alternates. And so that person gets to decide all the details. It's really important to have that too if you want to be cremated, because let's say, husband and wife, the last of them has passed away. You got 3 kids. One says, oh, mom wanted to be cremated. One says, no, she didn't. So whoever is on that funeral designation gets to decide. And I've had calls before here that said, the funeral home won't do anything unless all 3 of us sign. And I'm like, you don't have to. You have one of these. And so I get the call. We email it over to the funeral home. And it's the one lady at the funeral home said, oh, you're a blessing. I wish everyone had one of these. And I'm like, send them to carrier law, we do them as part of our package. Yep. Yep. So that's important to have. There's a new law regarding that. I think too, I'm kind of going into the estate planning stuff right now. We talked a little bit before about the importance of having a trust. But I think powers of attorney are really important. They're documents for you while you're alive. And one is if you become incompetent, powers of attorney cease when you die. They're no longer effective. But like a financial power of attorney, you need somebody that's going to be able to pay bills, do that sort of thing. Healthcare, whether you do or don't want life support, what kind of treatments you want. That's all for your healthcare agent to decide. Yes. Yep, they're separate forms. So. Yep. Kier, did you still have a question?
One of the questions are, what procedures are necessary when there are decedents and spouses that create and co-trustees of the same trust, and the spouse survives but retains beneficial control of all trust assets? Are there any procedures?
So does anything need to be done in the event,
A
basically, a
spouse
surviving
dies.
spouse?
Yeah, we usually do here if somebody calls and says my spouse died and they were clients of ours and they have a trust, is we usually recommend that they come in and do a surviving spouse trust review. And there are certain things that are supposed to be done when a person dies, especially even if it's your spouse. We have a don't break the law package where it is publishing that notice to creditors that Heather talked about, as well as the will is supposed to be filed with probate. Even though you may not be probating it, it's supposed to be filed as the person's last will. We file that along with a death certificate. Donna sitting over there does all that work for us and gets that publication notice. When that person comes in, we do a quick review with them. Are there things that were just in the deceased spouse's name? Are there any things that need to be moved? Check real estate, make sure, they were joint as husband and wife on the real estate, those sorts of things, or that it's in their trust. So we do kind of a quick review of all their assets. Also go over their trust and make sure, do they need to update trustees on their financial power of attorney? Do they need to update, they may have an alternate there, but especially in blended families, it may be the deceased spouse's child and they may want their own child, making those kind of decisions. Hopefully that answered his questions.
Can the court name a personal representative other than a person that you have chosen? Can they override your decision on your personal representative?
They can. There's got to be a reason for that. Whether the court can override the personal representative chosen in your will. There are certain things like if the person's been convicted of a felony and one of the beneficiaries says, I don't want them, they just, stole $50,000 or whatever. The court is likely to disallow that. And beneficiaries can come in and object or other people with the same standing as to who the PR is going to be. Rarely do you see that, but it is a possibility. The courts have pretty broad power, especially in probate court, sometimes more powers than other courts. Okay. Sure.
Okay. Wills are generally public.
Mhm.
Trusts are generally private.
Correct. The question was, wills are generally public and trusts are generally private, and that is correct. A will, like the wills that we prepare along with trust, our wills are what we call a pour over will. So it will nominate who you want as your personal representative, the term we use for executor. But then when it says who gets what, it says it goes into the Smith Family Trust or whatever the name of the trust is. And so if there is anything that has to go through probate, sometimes if you have a trust, there may be one or two assets that didn't get funded or somebody, opened up a new account. We like to try and take care of those with that affidavit of decedent successor for the under the 28,000. If everything has a beneficiary on it, is joint or is in the trust, with the exception of vehicles, there won't be anything to probate. And now vehicles, and I should have looked this up before I came today. It used to be a total value of $60,000 in vehicles could be passed to the surviving spouse or the children without any probate. That's being increased to 100,000, but I don't know the date. It's June 1 or July 1, I think. It's a change in the law. And boats is up to 100,000.
Now, if you've got a trust set up, and a lot of people are setting up trusts for maybe a family fund and working. How do you go about, since the trust is private, I assume the executor, or what do you call it? Representative?
Trustee, maybe?
Trustee
Mhm.
Will be, how do you make sure that that trustee follows the terms of that trust and distributes things correctly? Who has a double check on that trustee?
Well, if they hire an attorney like our law firm, we're double checking it and telling them you can't do this or you can't do that. However, there are ways to change it. If all of the beneficiaries agree to it, we can do an agreement to alter shares, but otherwise, usually the attorney that's managing it does. The beneficiaries are entitled to the portions of the trust that apply to them. So if it says I'm supposed to get 25%, they may not get the whole trust. They may get the portion that says they get 25%. They will get an accounting to show how much money is and the inventory to show how much money's in the estate, what's going through the estate, what's left over.
So let's say you have a relative that doesn't want to give anything to one particular person. And they're not gonna tell that person about you. So
And the person was left something in the trust, and we have,
is there a way that say, dear person, go talk to that attorney firm. They drew that trust up and they can tell you whether you're mentioning them. I cannot tell you. How would that be handled?
the problem that I see, it would depend on the exact facts, and I'm not sure if I have them correct. The question was if a beneficiary came to the trustee and wanted to know if they were receiving something.
Why is it not
Yeah, and are you saying that maybe they were disinherited in the trust?
maybe provided else in the trust, yes.
Mhm. The attorney has an attorney-client privilege that they're limited on what they can disclose. And so we usually tell them, talk to the trustee about it. We like to have things go through the trustee. It cuts down on time that we're billing on an hourly basis. So it cuts down the time that we would be charging the estate. Now, we do have some beneficiaries that will get their own attorney, and the attorney will send us a letter. We want this or we want that. And usually Heather gets it, screens it, and says, does it look okay? Yeah. And she'll do a letter for either her signature or mine. I review it and review what we're sending out. So,
And there would be a check of, some type of a check that you would normally expect with the trust. The trustee should send something to all the beneficiaries saying,
Mhm.
even if you're perhaps a contingent beneficiary.
mhm. Yep. And if
Mistakes are made sometimes.
they are, and as a beneficiary, you can always go to court. That's going to increase the expenses and the time. I usually say you don't want to go to court because the only people that win when you go to court are the attorneys. So, and you don't usually, oh, it's the principle of the thing. And I've done litigation too. By the time you're through a case, they're like, I am so sick of this. I just want it to go away and go settle it. So we try to talk to people up front if we've got the person that's kind of complaining. But that's part of it.
Something you could- Somebody could say, like, since this is private, I guess the court can't do it. Probate and say, look, I'm a judge. I looked over this trust, you ain't in.
They can, if the beneficiary goes to court and asks for that, then it becomes a court matter.
And
There's filing fees. I think they start out at like $187. And it can, and we talk about trying to get along. If you want, sometimes like we see this with joint bank accounts. Okay, the joint bank account, you were joined on it. I'll tell somebody when we're meeting with them, it's yours. You don't have to share it with anyone. But you know what mom or dad wanted. You're going to do what's right if you want to continue to have a relationship with your sibling. And I leave it up to them. And every once in a while I'll have, well, I took care of mom and dad and blah, blah, blah. And they wanted me to have that. Okay. Legally it's theirs. And so we go with that. Other times, oh no, I want to have it shared. So depends on the family.
well, being an executive of the estate strikes me as a somewhat task.
A somewhat what?
Thankless task.
Oh, yeah, it is.
The really unfortunate situations are the ones where the executor is not a beneficiary. So it's a really thankless task.
But a trustee or personal representative can charge a reasonable fee. I know Kent County, this was a few years ago, but not that many. Judge Murkowski, he's now has another judge, so there's two of them in Kent County. But he one time's questioned, usually $20 to $35 roughly, unless you're an accountant or a financial advisor, is pretty average per hourly fee. But he contested that we were paying some of the relatives, I think $20 an hour to clean out the house. Oh, that doesn't take any knowledge, blah, blah, blah. You should be able to do that for $10 or $15 an hour. And I'm thinking, I want to know who's doing it for $10 or $15 an hour because my house needs cleaning. You know? So you never know. If you're in court, that's the thing. If you're in court, you never know what the judge is going to do or say. I mean, I practiced in front of Judge Murkowski since he took the bench. So when I was hired here, that was one of the questions. How do you do in front of Judge Murkowski? And so he and I get along well. So most of the time I get what I ask for. Sure.
When you see on television, a television show, you always see, oh, they're dying. We have to have the reading of the will. I didn't think that happened.
Do you want to answer that one?
Yeah, a lot of people think that, and a lot of beneficiaries will expect to have some sort of reading of the will. The reality is there's no reading of the will. If you're a beneficiary, you'll get something in the mail and find out what you're entitled to. We do have people come in occasionally for their initial meetings and they bring the whole family, and it's not the end of the world, but we do like to avoid that primarily because of what Terry mentioned before, attorney-client privilege. It's really hard for the attorneys to speak candidly with these trustees and personal representatives when the entire family's in the room. And sometimes they don't know exactly what the trust says until we're all sitting down together, and that can be an uncomfortable conversation to have with everyone there. So
You had one, I don't think I was there. I think it was one of our other attorneys that one of the beneficiaries, one of the kids was disinherited and he was sitting right there. And what did he do? Say that was rude or something and got up and left?
his feelings were hurt and he left, and our client, the trustee,
know.
didn't even know before going into that meeting that they were going to find that out. So we typically would prefer to just meet with whoever is named as the successor trustee or personal representative in the will. And then from there, kind of come up with a plan for speaking with the rest of the family and passing along that sort of information in a sensitive way.
Did the beneficiary ask the attorney firm that made the will out for a copy of the will?
We provide the sections that pertain directly to them. So with the will,
Will is-
I mean, if it's getting
That goes to
probated, they get a
court.
copy of it.
It goes to court.
not-
But
The original does need to be
Yes,
filed with the
it does.
court. Yep.
you actually can't get it off the internet, but you go into court
Get a copy.
and get a copy.
Oh, and then you have to find-
Mhm.
You have to go in person.
Yeah, for us, if we have beneficiaries that request copies of documents, we just check with our client and say, do you want us to send a copy?
Client's dead.
The trustee or
trustee
the
or
personal
the person.
representative, whoever is administering the trust or the estate.
They're considered our client after death.
Mhm.
The trustee is. And so that's who we owe our duty to, would be the trustee or the personal representative.
So, yeah, we just let the trustee know by law what they need to do and then leave it up to them as to what they want to do. They don't necessarily need to provide a full copy of the trust, but they can if they want to. Most people do. I think most
Mhm.
families like to provide some transparency and, you know,
And we cannot give beneficiaries advice
Unless they're your client.
unless they're our client. Yes.
Kier, was there another question?
The question is in regards to our attorney documents after the person falls passed away. It says that the personal representative or executor now become the person who handles all of those issues.
Yep, so powers of attorney become ineffective after somebody has passed away. So if you have somebody named as an agent handling your financial affairs, they're no longer going to be able to access those accounts once you've passed away. unless those accounts are in trust and that person also happens to be your trustee. So if you don't have a trust, that person is named as your personal representative. Before they can access those accounts, they would need to open probate through the court, get officially appointed as the personal representative, after which point they would receive the documentation from the court giving them access to those accounts. Yes,
Designate somebody as a power of attorney,
yes.
or you
Mhm.
then you die, then that power of attorney goes away.
Correct. It is only for while you're living. So your financial power of attorney is somebody that you want to be able to make financial decisions for you or assist you with financial, with your accounts, paying bills and whatnot.
Persons who have the power of attorney while you're living are also the trustees. of the trust.
Exactly. Yes. Yeah.
And then have the account in the name of the trust, because if you have the account just in your name, the trustee doesn't have authority over the account. But if the account pours over into the trust or is already like in your family trust, then your trustee can take over.
Mhm.
What about the, maybe you're gonna tell me the trustee, but I die.
Mhm.
And there's, I owe a small bill for this and that and everything like that. I was under the impression that the person with power of attorney could take care of those details. You're saying, and those things don't necessarily transfer directly into the trust, do they?
The
There's
bills,
liabilities.
no,
So the trustee takes care of those things. So in effect,
Mhm.
a trustee has the same powers as the power of attorney. In effect.
Once you've passed away.
yeah,
Yeah.
and
Yes.
And with those bills, we usually tell people not to pay any of them other than like the utilities, keep the house insured. But the other things like the doctor bills, the hospital, the ambulance, credit cards, we recommend not paying any of those until that 4-month time period after we've notified creditors and put it in the newspaper until that runs. Usually when we do a trust, there's nothing going through probate because we work very hard with our clients to make sure they get funded, that all the stuff gets put into the trust. So then there's nothing going through probate. So when we get those credit card bills and things, we send a notice of disallowance to those credit card companies, the ambulance, and usually those companies, unless they're really big dollar amounts, like $20,000 or so, they just close out their accounts and you don't have to pay them. I tell people though, once we know there's enough money to pay all of them after the 4-month time period, if it's what you want done or the trustee wants done because they think ethically they need to pay those, they can. But if there's not enough money to pay all of the bills left in the estate, then after that 4-month time period, you'll know what all the claims are and you know how much money you have. Then if you want to pay those creditors, you can't favor one over the other. They have to get paid, 10 cents on the dollar or whatever it may be. But we usually try and set it up so all those random things our clients don't have to deal with. A lot of times they don't know on credit card bills whether it was a legitimate charge or not. So,
So, my goal is to make it simple. Okay.
Mhm.
And that's why I was asking about separate trust this, separate trust that.
Mhm.
So, in the case of one spouse dies, okay, the other spouse basically probably has joint ownership of a home and vehicles and other stuff, and that just automatically transfers over. But in terms of any other part of the trust that's been set up, at that point in time, I think you recommended that you have a surviving trust package. So the surviving trust person comes in and says, okay, what do I need to know?
Right.
You'll have, if you will, a checklist for them.
Pretty much.
Pretty much. And that first meeting with either the surviving spouse or the trustee or PR that's coming in to meet with us and said, my loved one has passed away, that first meeting we don't charge for. And so we give them an outline of what we'd recommend. And like if it's a surviving spouse, we'd recommend the will get filed and the notice to creditors. maybe nothing else needs to be done. Maybe all their alternates on their powers of attorney and everything are good, but you know, if your spouse is listed first, you're gonna have to have a death certificate, like if a child is next to use.
What role does trustee have? Because the spouse presumably is also a grantor
Mhm.
trustee and has full control.
Right,
So you don't need a trustee.
Right,
in
the
case of a
successor.
spouse. But
Right.
when the spouse, when both of them die, then it would be appropriate for the trustee to say, hey, Carrie, what do I do?
exactly.
And it
Yeah.
would be a similar thing of.
Yeah.
of, if you will, a checklist. And these are
Right.
steps
Yep.
you need to take.
And sometimes for the surviving spouse, depending on how old they are and how they are in handling financial assets and things, you know, we'll ask, do you think you need a co-trustee? So they may want a child on with them to help manage the trust. They don't have to do it. A lot of times, I would say, you know, you look young and vibrant, like you're getting all your own stuff done, but is there any reason you would want a child on with you or one of your successors? And so it's just one of the things. They don't have to do it. It's just something we talk about. And sometimes they're like, not right now. I just spinning, you know, my spouse just died. It's like, fine. You know, call us back if you have questions or want to make those changes.
But if, you know, let's keep it simple thing.
Yep.
Assuming that something happens, competency becomes an issue, health,
Mhm.
whatever. If you have trustees set up in advance, they've agreed to be trustees and
Mhm.
everything. Is it simply a matter of in this case, I'm talking about the surviving spouse,
Mm-hmm.
just say, okay, so-and-so, whoever it is, I need some help.
Mm-hmm.
Is it that simple?
No.
This is what I
They-
drives me crazy. It's almost like it seems more work and more complication than it's worth. Because in my particular case, I don't have a business, I don't have a farm, you know,
Right.
it's pretty straightforward. Assets and fairly liquid. And so to get a trustee, to, you know, have to go through all these hoops and everything. Quite honestly, seems like a burden for them. I mean, it's a burden for me. I've read the trust probably thoroughly 3 times, made notes, put sticky notes and stuff like that. And the reason why I'm here is because every time I go through it, I hear something different.
Yeah. To add that co-trustee on, let's say you passed away and your spouse was in here and she says, you know, I really think I need some help. And I want children,
Yeah.
son or daughter, or
But they're not trustees.
okay. Well, who's your
Never will
successor? You know, a friend? Okay. I want so-and-so successor trustee to be on here with me. So then we would do an amendment to, there's 2 trusts most people get. One is a revocable or a family trust. The other is a protection trust. And so we would amend that revocable trust to add on that trustee, that co-trustee. And then we would also do for the protection trust, we do something called an exercise power of appointment. It's basically an amendment. So we would amend both of them to add on the co-trustee that they want. The co-trustee, you can't force them to do that job, so they have to sign an acceptance of trust. And then when they do that, we do the amendment. Then we also update the certificate of trust existence, which is the short version of the trust that you show the bank that says, I'm a trustee on this account and I have authority. And it's the same thing you would use if you had to sell the real estate.
Doesn't a grantor trustee have the right to say, basically, I want Joe Blow to be associate trustee?
Mhm.
How is that different than if the grantors and before that say, okay, here's a person or persons that I want to be trustees and everything like that. They signed a paper saying they're willing to do that and everything. Why does there need to be an amendment to the trust forms because you already have it.
It's a
Duplicate.
Yeah, it's a successor usually, so they aren't currently a co-trustee. And so if you're adding on somebody with you so that you both can act, that's why we would need to amend it. If you were both dead, let's say, and you got your successor trustee there, they still have to sign an acceptance of trust that says, yep, I'll do this. And then we update that certificate of trust existence to show that you've died and also that who the new trustee is.
I hate to be thick here, but you've already signed a piece of paper. You're a trustee that I've chosen. You signed a piece of paper saying that I'm willing to do that. And you seem to say, well, that doesn't count. You gotta do it all over again.
Well, the successor trustee usually has not signed the acceptance when you do the trust. And so you've got to have that paper trail for the banks that are really complicated with, how do we know we're dealing with the right person? So,
Trustees that I select.
okay,
They're mentioned in multiple sections of the thing. So.
Right.
Trust already recognizes who these are. And then there's a separate document that they have to sign that they accept the responsibility. I understand that.
right,
You don't have to take that.
right.
But their identity, if you will, is already in the trust documents.
Of who they're going to be, but they still need to assign and accept that. And then you don't want
They
them,
do. I give them the paper, they sign it and say, okay.
yep,
And basically, grantors, as I understand it, grantors still have control until they die.
Mhm.
And at that point in time, I guess my assumption is that these people that I had selected and had signed and agreed that they automatically were the trustees, we take over.
we hear that from a lot of people. Did we do your trust here at Carrier? Okay. Yeah, it's sometimes we have people when they initially set up their trust, grantors, mom and dad, grantors, and mom and dad and son John, trustees. So you're already set up initially as trustees, the three people in my example. And then the son would also have to sign when that trust is being set up. But if they're a successor, it's only when you are no longer acting as trustee. So that's why they have to sign later. And when you got new people on there, you got to have something to show a title company or a bank as to who has authority. And they have specific requirements, like on statutes and different things that have to be in there. The title companies usually want those certificates of trust updated within 6 months to a year before the property sells.
Mhm.
So,
Well, and the other reason being too, what if you were to change your trust after the initial trust that you set up? If you make changes down the road, you wouldn't want those initially named trustees to be able to just act after your death, even if you changed your successor trustees down the road. People change their trusts all the time, add people, remove people. So that's another reason too.
I understand that.
Mhm.
I'm on my second amendment.
Yeah.
okay.
So I understand when the circumstances change, but what I'm struggling with is that the circumstances, other than the amendments I made, haven't changed as far as who's gonna be the trustees and stuff like that. And again, I'm trying to make this as simple with their administration as possible. They haven't sat through your workshops or talked to people such as yourself, and I don't want to take up everybody.
Yeah, well, if they come in for a meeting with us, we would walk them through that. And, ask them if they want to retain us to do that work. And then they come back in about 2 weeks. If they did, Heather will have a nice little packet for them, sign here, sign here, sign here. Take these to the bank. So it sounds complicated, but it really isn't.
No.
It does sound complicated, and it sounds like that basically, from my perspective, I'm sitting here trying to get all my ducks in a row. I died, my wife dies, and guess what? They gotta go through almost, it sounds like the same process. You might think it's simpler, but a whole other process to say, yeah, we're legit, we can do this, and we can talk to the bank, and we can do this, and we can do that, and.
The main difference is the protection you're getting with a trust. So at the end of the day, there is going to be work involved, whether we're administering a trust or we're going through the probate process. Unfortunately, that's just the reality, is there's work to be done either way. The nice thing about the trust, I would definitely not say it's more work. From my perspective, doing the work, it's less work for a bigger benefit, but it just depends on what's important to you.
How long has it been since you've been in to see us? To look at your last week? Okay.
Meeting Wednesday.
Okay.
Have so many pens, I don't have enough.
I was gonna suggest if you needed to come in for a one-on-one, we could do that. But it sounds like you've got that set up. Are you meeting with Claire maybe next week?
It's a name I can't pronounce, at least that's the name on the email. This is the.
Would it be
sign
me?
and paper,
What?
the amendment. This is
To
the
sign an
and paper.
amendment?
Usually,
Unpronounceable name.
usually Claire does our signings. So, all right.
I mean, quite honestly, I walk away and I say, why don't I just go through probate? I don't care who knows.
Well, but if you end up in a nursing home on Medicaid, state of Michigan's gonna
Yeah,
take your.
that's fair. That's fair.
So,
Mhm. And the other nice thing too is with the trust, it also provides more protection for your beneficiaries, depending on who you want your stuff to go to. With probate, it's going to them outright. They have no options for protecting their money.
there's nothing wrong with that either.
Yeah.
Spend it all.
Yeah. Something.
There you go.
So can you have more than, can you have two trustees?
You can, but we don't typically recommend it just because a lot of processes are not set up to be co-trustee friendly. As we're, liquidating assets, for instance, cashing out accounts, transferring IRAs, that sort of thing. All of that's set up for one person to sign off on. And we can make it work. It just ends up being a lot. And it also, you want to make sure both co-trustees are local. Because it's, if you have somebody who's across the state or out of state, that really complicates things. But if that's what you're more comfortable with, we do provide that option.
Mine, so, if they modify the trust, it can be reviewed, modified, because the only issue I have is the person that the grantor is not capable of coming inside.
They can modify the trust after someone dies, only if all beneficiaries agree. It goes back to an old, what was it? I'm drawing a blank now, the Dodge Family Act, settlement agreement. Back when the Dodge family that have all the cars and, everything, they were fighting over the estate and it became a law, that they could just ignore all the documents and come together and all agree and distribute it how they want. And so in that sense, we do agreements to alter shares, but everybody has to know what they're giving up and what they're getting, and they all have to sign. But changing the trustee can't just unilaterally, like a successor trustee, can't change it. The grantor can, the one who initially set it up.
Mentally not dead, but mentally incapable of executing the trust, then it goes nowhere. No matter what the beneficiaries do, if they're just incapacitated, then the trust is minimal.
Well, then hopefully the trust has a successor there. There are ways to get that trustee removed, either two doctor statements or our trust. We put that disability panel in there that says John, Sue, and Mary can all vote and determine if they're not competent, remove them, then the next person in line would come in. If you don't have those provisions within the trust, you can always go to court.
They are also very expensive. When I
Yeah, and if, well, you could have just one trustee, and then if that person's unable or unwilling, then the next person in line. If you want to, we can do that. It just makes, it kind of slows down the process, because a lot of times then it's like, we need both of you here to sign. And it can be cumbersome. And if the two of you don't get along, we're in court anyway. You know, when I say the two, I mean the two successor trustees. We try and keep it all out of court if we can. That's our goal.
Paperwork wise, like I said, specify, it's like, it'd be much easier with they do with it up front. Modify the trust.
And you can, and if like your successor trustee that you have in your own trust is losing it, or you don't like their financial decisions, you come in and you modify your trust and get a different successor listed.
It's physically incapable of executing the trust. It's not whether I like them or don't like them. Well, that's not an issue with that. If I already know they're incapable of executing the trust, you know, I'm acting as the representative of all the beneficiaries.
Yep. Right,
Power.
right. So,
You have multiple trustees, then all of them have to agree.
It depends.
you're here, you talk.
Yeah,
You
sure.
saw me take the big breath, like.
Yeah, well, and that's the other reason we just don't love the co-trustee situation. However, if you want to name co-trustees, at least in our trust, usually you can have it set up in one of two ways. There can be language that states that the trust requires signatures from both trustees in order to accomplish anything. Or there can be language that says one signature is acceptable. So that way one or the other can act. And that's just up to, you know, each individual family and what they choose to do. And those scenarios are a little bit easier on us anyways, when only one can act. Sometimes when we have co-trustees too, right off the bat, one of them says, I just want my brother to handle this, and they'll just resign and let brother handle it. So there's always that too. But the real issue is when we have co-trustees who hate each other. And
Or
then
we
it's a
have
struggle.
Co-trustees from a blended family sometimes. makes it
Mm-mm.
tough.
Yep. Exactly, or co-trustees that are, you know, one is in state, one's out of state. A lot of times, one of them just resigns. The out-of-state person usually says, this just isn't gonna work. I can't show up for these meetings. I can't put in the same amount of effort. You know, with the forms that need to be signed, you know, it's 2024. We can do a lot of stuff remotely, but when it comes to having things signed on the same date, for certain companies, the
Yep.
claim forms, it
In front of
really
an
gets
elderly.
complicated. Yes.
But ranking over co-trustees, why don't you just make it 3? I'm being serious.
I've never seen it. I assume anything's possible, but I don't even know where I would begin to start trying to liquidate assets in a trust where, like I said, these claim forms for companies, say you have an IRA, we're trying to get it cashed out or transferred to inherited IRAs. Who's going to sign the form? Which trustee?
Well,
There's
let's-
only one signature space on the form, then what? And then Fidelity says, what's this? I'm not accepting it. It's
well,
just complicated,
and
very
sometimes we get
complicated.
Grantors are getting older, and you know, they have a child that's helping them and takes them places and does things. So sometimes we will name those 2 grantors as trustees of their own trust, because that's pretty standard, and we'll add a child on with them that they want. And then we set it up so that any one of the 3 can sign individually.
Wouldn't that be the same thing as assassin?
No,
If you have the language that states that only one of them has to sign, but then you're still potentially going to run into issues with the co-trustees not getting along. If one of them just takes off and starts signing everything on their own, technically they might be allowed to, but if the other 2 don't agree, then you're in court.
Always.
it's what comes first, the chicken or the egg. And You can do it. We don't always recommend things and, sometimes people do things against our recommendations and we just make sure that we clearly note that you were advised blah, 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 and you still wanted to do it that way. So.
I understand that you have to look at the. I understand that you could probably. Tell me about all the exceptions that you come across, all right? I get the sense most of the people here don't have families that are gonna go see Judge Judy and have, some faith in the people that they want. And to this gentleman's situation, if you, and this is what I'm trying to wrap, I have 3 people that I've designated that are in the trust document.
Successor
and
trustees.
everything like that. Both of us pass.
Mhm.
All I want to achieve, and maybe you can tell me how to achieve that, is that any of the 3 can sign. They're all equal. And I don't have any reservations, and if I get screwed, I won't care at that point.
Yeah.
You would need to list them as all equal, currently together as successor co-trustees.
And then I would say you're probably gonna wanna make sure that the language states that only one of them needs to sign.
Guess I'm gonna have to look at exactly how it reads, because all 3 names were mentioned multiple times in the
Yeah, so,
trust document, but whether it has the language that you're talking about, I'm not sure.
well, I can guarantee they're not all co-trustees right now, because we would,
Robert, before you leave tonight, give me your last name and I'll get together with the attorney that did your drafting and
Because
look at it.
That's what I'm looking to achieve, because I have absolute faith. It's a family unit. And I, and they have different expertise. One's a doctor, one can do the finance, and the other one's my sister, and she's gonna do whatever they tell her to do.
Mhm.
Tell them to do. That's the way it works.
yeah,
Okay, I'll give you one.
yes.
A different item, I wanna get down to stepped up things.
Stepped up basis.
Oh,
Most of us, the big thing we have is the family.
right.
And we want that to go down to the kid, he's a vacation, or living, and he wants to step up, blah, 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 blah. And I understand it goes through a revocable living trust, you're okay.
Right.
But I've heard some horror stories depending on if that sucker gets stuck in the trust somehow, we lose the stepped up basis.
So the question is, stepped up basis, which just to explain what you're talking about for those who may not know. Usually when you buy a house, and I use a real simple example, let's say you buy it for 10,000 and then you die and it's worth 100,000 and it goes to, according to your trust or through probate, either one, you get what's called a step up basis. So normally if you were still living and you bought it for 10,000, sold it for 100,000, the basis is the 10,000 and you're going to have to pay capital gains on that 90,000. But when it goes through the trust or through probate, you get a step up in basis to date of death value. It depends on how the deed is drafted. And we are very conscious of making sure you don't lose that step up in basis. We are also very conscious of not having the property uncapped. And there are exemptions. When I'm talking about uncapping, there's the taxable value when you're paying real estate taxes and the state equalized value, or what they call the SEV. The taxable value can only go up a certain percentage. That's based on the Headley Amendment that passed a number of years ago. And so usually your taxable value is less than your state equalized value. If a transfer is done, like you sell it to a third party, it's going to uncap and their taxable value is going to come up to the state equalized value, which means their taxes are going to go up. When we pass it through probate, trust administration, there are exemptions. There's a property transfer affidavit that has to be filed. And we're always very careful to make sure we're checking one of those boxes or attaching a statute that may not be on one of those boxes, so that we don't uncap it. So we had a few problems way back when with our protection trust, and I'm talking before I started here, and I've been here 8 or 9 years. We started adding the protection trust. Yes, we started adding life estates to them. And so that gives you that step up in basis. So the deed, you might be deeding it from yourself. Let's say your last name was Smith. From yourself to the Smith Family Protection Trust, but we would retain a life estate for you personally on there.
That way you get the step up in basis.
Yeah, that way you
with
get
date
the
of
step
death.
up in basis at date of death. We sometimes do a 1% life estate deed, which that's way too complicated to discuss today.
So that, okay, that scares me of anything
Mhm.
like that going into a trust. Because
Mhm.
I mean, that's a hunk of money. to lose.
It is. It is.
So you would have to have those assets that can appreciate in value, either directly go to the beneficiary.
You don't want it to go directly to the beneficiary, like a ladybird deed works because it's, sorry, it's got a life estate language in it. It says, for my lifetime to do with as I please, I can sell, blah, blah, blah. And then, yeah, it's an enhanced life estate deed with a contingent remainder is what it is. But people call them life estate or ladybird deeds. And those you get the step up in basis because it's got the life estate written in there. But if you just deeded your property right now while you're alive to your kids, and then they would not get the step up in basis. They would get what your basis is. Or if you deeded it from yourself to yourself and your 2 kids and didn't retain it until you died and you all sold it, everybody's gonna have to pay they're gonna get the lower basis. And I am not a tax accountant, nor an accountant. So,
Like, I just found it now.
does it make sense what I'm telling you? Yeah, 'cause I've-
like the state
And a person can terminate a life estate on their own if they deed it away. But normally a life estate, let's say you give property to someone and you retain a life estate. When you die, they just record the death certificate and it frees that property up. Same thing with that enhanced life estate deed or the ladybird deed.
What confused me, struck terror in my heart, that didn't affect us, but, someone deeded a piece of land to a township to use as a park. And they said, if you ever decide not to use it as a park anymore, you can't just sell it, it has to go to the family. And somehow they.
That clawback where, if you're not gonna use it as a park, it has to come back to the family.
Yeah.
I don't know. I'd have to ask David on that.
What happened, what I would have thought that when that deed went, that there would have been some mention in the deed of there being a life estate or a clawback or some fancy little attorney wording that the attorneys do.
I don't know. I'd have to
And,
think
yeah,
through that.
And I know that, what I know is that the township tried to sell it to get money. And one of the other neighbors that was old and remembered, went to a meeting and said, blah, 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 blah. And they somehow decided that the blah, blah was right and it didn't get.
But there wasn't,
But something.
there wasn't anything in the chain of title at the Register of Deeds, which is what you would want to.
You'd think there'd be, when you take stuff, that's a black hole.
Yeah, it's the Register of Deeds. If it's not recorded there, as far as I'm concerned, it doesn't exist. But, they can pull them out and people can say, but I have this. And
Whatever.
maybe. Yep. I'd have to look at all the documents and probably lay them out.
sleep on it and wake up in the middle of the night. And say, why didn't I think of that? Or driving down the road, that happens to me, others, that's what happens to her too, you wake up in the middle of the night, so. Anything else? Okay. Well, we'll be here for a few minutes anyway, if anyone has any questions.
Thank you. Yeah, you're welcome. And if anybody's interested, I can send the PowerPoint out via email if anybody wanted a copy of it. Yeah, if you